And thank you very much for joining us here on PM Express as we count down to election 2020, which is just 20 odd days away. There are a lot of things that we all must get right. And as we prepare as media, as the parties prepare also for what is expected to be a keenly contested race, well, one of the arms of government that you rarely hear about, the judiciary, is also very actively preparing for, as they say, any eventuality. And that is why tonight we are going to be examining the election adjudication and the 2020 polls, because His Lordship, the Chief Justice, having constituted a committee, have come together to put a few of his colleagues together and have developed a very comprehensive guideline that details what will happen or what should happen as you adjudicate issues surrounding the elections with the impending 2020 polls. And tonight we are going to be looking at that. It's such an important part of this democracy that we practice. If you recall, in 2012, this became absolutely relevant in the petition. The first time in our fourth Republican history that this has gone to court at the presidential level. It went on for months, but we learned a lot. And as we begin to have the conversation, you begin to see how the lessons we learned from there have influenced and impacted on legislation going forward to make this democracy even more enhanced and entrenched as never before. And so let's go into some of the key things that we expect in the conversation tonight. And you don't want to miss this for anything, because trust me, these views are part of any electoral process. If it doesn't happen at the presidential level, it almost certainly happens almost all the time at the parliamentary level. You may not hear about it as prominent as the presidential challenges are, and that is why this is absolutely critical. Now, as part of the preparations towards the elections, the Judicial Service have put together this all-important manual. It provides an easy-to-read compilation of all relevant information and resources that, of course, all the stakeholders will have to follow on. Tonight, I've been reading about it, and as you can see, as journalists and media practitioners, this will help us a great deal in understanding. What I find fascinating is that it also tells you about some of the most contested issues in recently. I mean, with the Electoral Commission, the processes towards elections, the things that we've debated about for months. There is so much clarity and simplicity when you read this document that the Chief Justice, of course, leading with his colleagues, have put together. And I'm just excited, waiting to get a bit more clarity on what this is. It's 10 chapters. There's a lot in there, combined. A resource book for all requisite constitutional provisions on the conduct of both presidential and parliamentary elections. All the controversial items that you've heard before, just grab a copy of that if you can find. I'll tell you where you can get a document. Read it. It offers some clarity on a number of the issues. It includes statutory and subsidiary legislations, as well as relevant and special procedural rules on the conduct of the elections. And that is what I was emphasizing earlier. What are some of the key areas that you need to be watching out for as you go forward? The hierarchy of the courts in Ghana, showing the jurisdictional limits in election disputes. That is very key. We've had people in election cases go to the wrong forum and on procedural grounds has been thrown out. This spells out very clearly where you have to go. You don't have to just rely on your lawyer, by the way. You can read this and be informed. You can be your own pocket lawyer if you have an issue relating to the elections. Also, election disputes raising issues of interpretation and enforcement of the 1992 Constitution. Don't worry, we'll break this down for you shortly. Exclusive jurisdiction of the High Court also in determining parliamentary election disputes, all spelled out in this document. The Supreme Court's own role in this matter of presidential election disputes, as we saw in the 2020 elections after the polls, and what the MPP did by going to the Supreme Court. Also, electoral offenses and sanctions. For me, this is key. if everybody's going to participate in the election some way, somehow. Either you are voting or you are possibly just monitoring, even if it's on television. You have to learn what the offenses are and what the sanctions are, so you stay clear of them. And so this is also in this particular document as well. So that's why this is important. A determination of claims and objections arising in the court of registration of voters under this CI, one of the controversial CIs, and of course, as amended by the CI also. Now, listen, as I've already explained, this is a document you want to grab a copy of, definitely. But this is just to give you an overall picture. Tonight, I am delighted, for the first time in my 16-year journalism career, I get to speak and have a conversation with a sitting Supreme Court judge. You don't get that happening often. And so we're going to sit on his feet, obviously, and have a conversation about this. He's His Lordship Justice Kulendi, who is joining us on PM Express tonight. We're going to take a break. When we return, we'll get into the conversation about election adjudication, the importance of the latest update in the election adjudication manual put together by Justice Kulendi and his colleagues at the Supreme Court. Stay with me. And thank you for staying with us here on PM Express. As I indicated at the beginning, we are joined by His Lordship Justice Johnny Kulendi in the studio with me. Justice Kulendi, thank you for your time here on PM Express.
Thanks for having me, Evans.
Grateful to have you on the show. It's just appropriate, I guess, in the times that we're in, as we still mourn the passing of the former president. The sitting president has declared a 7-day period of mourning, which expires, I guess 2 days away. I know every arm of government has paid its tribute to him. What's the fondest memory you have of him? What's your recollection of the man, just as former President Rawlings?
Thanks, Evans, and good evening to your listeners. And for most people my age and generation, the leader who has impacted our lives and experiences the most is President Rawlings. I must say I had a personal privilege of meeting President Rawlings, as I had the opportunity to say. He and I had a mutual friend and brother. Riyad Huzaifi, and we got to connect, as I said fondly somewhere, after I had all my tricks to avoid President Rawlings had failed. But for those who haven't met him in person, you have missed a very unique and intriguing individual by every count or consideration, a very extraordinary person. He provokes conversation as he wants. And as I had the privilege of saying somewhere, President Rawlings commented on my haircut, my tie, my cufflinks, my shoes, my socks. And he's a very warm individual, and I think that it's a loss to our generation, to the country. The week of mourning is the right thing to do by His Excellency the President, because by every standard, President Rawlings is a key actor, if not a major actor, by far the most significant in the history of the Fourth Republic. And he's a loss to to us as a country and a society across board.
Yeah.
And to the former First Lady and the First family, I join the millions across the world to express my very profound condolence to them, and that we all pray that President Rawlings will find peaceful rest in the bosom of the Lord.
It's pretty interesting that we're talking about former President Rawlings within the context. Of course, on the day when, of course, our main advertised subject is judicial adjudication, the election adjudication, as it relates to the 2020 elections in particular. I say it's interesting because this constitution, which is the parent body that forms the crust of this document that your colleagues have put together, he oversaw its birth in 1992, ushering in this fourth Republican period, the longest in our history of democracy. The question needs to be asked, the link that interestingly exists between the judiciary, democratic governance, specifically elections, which Rawlings had a lot to do with in terms of the entire legal architecture that put these three elements together. What's that link there, if you may, between these three very important things?
The link is borne out by the very preamble to the 1992 Constitution. And to paraphrase, the preamble says that in the name of the Almighty God, we the peoples of Ghana, in exercise of our natural and inalienable right to establish a framework of government which shall secure for ourselves and posterity the blessings of liberty, equality of opportunity, and prosperity, and in a spirit of friendship and peace with all the peoples of the world, and in a solemn declaration and affirmation of our commitment to freedom, justice, probity, and accountability, the principle that all powers of government spring from the sovereign will of the peoples, the principle of universal adult suffrage, the rule of law, the protection and preservation of fundamental human rights and freedoms, unity and stability of our nation, do hereby adopt, enact, and give to ourselves this Constitution. This is the opening preamble to the 1992 Constitution. And you see the key themes that fall into the framework of governance feature here. One of the principles we affirm in the preamble of the Constitution is that all powers of government spring from the sovereign will of the peoples. That is why it is the prerogative of the people to determine who exercise the powers of sovereignty for and on their behalf. How do we do that? The principle of universal adult suffrage. This is the standard by which we go to vote. And we affirm the rule of law. Who sits as the midwives of the rule of law and adjudicates? The judiciary. So you go to Article 125 of the Constitution and you find repeated, and this is the part of the Constitution on the judiciary, you find repeated in practically the same language where it says judicial power of Ghana, and it says that justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. That Constitution we adopted and enacted for ourselves, in which we affirmed our commitment to the rule of law, to universal adult suffrage, which is to elections as the process by which we determine who, for the time being, is responsible for matters relating to our governance and the rule of law, the rules of engagement between us. And then the Constitution at Article 125 vests judicial power in the judiciary, but repeats, it's a reflection of the statement in the preamble that the powers of government spring from the sovereign will of the people. It says, justice emanates from the people and shall be administered in the name of the republic by the judiciary. And 1255 says the judiciary shall have jurisdiction in all matters, civil and criminal, including matters relating to this constitution. And because it is the constitution that sets up the framework of government, provides that we do it by universal suffrage, the constitution vests judicial power in the judiciary. And all disputes or matters, civil or criminal, and matters relating to the constitution. It means that if you are going to have a disagreement, first of all, even before you get to a disagreement, if you deal with the pre-election processes, the processes as to who meets the eligibility criteria under the considerations of universal adult suffrage to vote. And for that matter, the registration, pre-registration processes.
Very contentious matters.
Contentious, because that's where you set the stage. Who qualifies to participate in the business of going to the polls. All of those matters will be provided for either by the Constitution as the basic law, or by statute, other laws made by Parliament, or subsidiary legislation. Therefore, any matter relating to the pre-election issues as to registration, who can register, who is eligible, who cannot register, if there are disputes that arise in relation to those matters, they go to the arm of government vested with judicial power, and that is the judiciary. Then you come to the conduct first, and then you come to eligibility to participate and put up yourself to be considered for election at all the various levels, from the presidential election to parliamentary election, which is what is in our focus now. But to some extent, every other election, such as local government elections, etc.
Even internal party elections have ended up at
exactly. Beyond the association's own constitution and basic law, when the issues implode beyond that, you make the considerations within the general framework of law and sometimes the Constitution of Ghana. And therefore, the eligibility issues for who becomes a candidate, who puts up themselves, are all matters that can end up in disputes that will also end up with the arm of government vested with judicial power. Then you come to the elections themselves, whether presidential or parliamentary. And there may be issues, there may be disputes, there may be misunderstandings relating to the interpretation, meaning, application of one rule or the other, one statute or the other, one law or the other. There may even be issues relating to whether or not a law itself is valid or invalid, is null and void. All of those contentions, if they ever arise, as we have seen in the past, will end up with the court. Then the election itself, and then the post-election into the declaration of resource at all of the various levels. There can also be disputes. I guess it's in the nature of humans that wherever there's a contestation, wherever there is competition, wherever there's human engagement, in civilized society, you always would have rules. And wherever you have rules, there's a prospect or potential of infraction or oversight, compliance, non-compliance, conduct which is ultra vires, the powers conferred by the rules, etc., etc. And so all of those matters will have to go to an adjudicator.
Yeah.
And in the framework of government that we have chosen for ourselves, and the principles that we affirm right from the onset in our adoption of the Constitution, we put the rule of law at the heart of it. The Constitution vests the power, judicial power, in the judiciary.
Yeah, I mean, here's my question though. So the Judicial Service has found the need to put together a manual, but I wonder, since 1992, the laws are already there, right? I mean, why the need to now do a manual on election adjudication? I mean, when the laws are there, nobody goes to court without a lawyer anyway. They can find the laws and read, and we've done this, as we started with Rawlings from 1992, all the way to, I guess, 2012. It's important because then we had the big one, I mean, the election petition. It went quite smoothly. But I noticed that since 2008, this manual had been introduced by then Lordship George Wood. I wonder why did the Judicial Service find it necessary,
right,
to put this document,
I guess
together?
It's first of all bare necessity, or necessity that becomes self-evident, coupled with the inclination to be progressive and, for want of a better expression, to think outside the box. Now, in litigation or in dispute resolutions, there always invariably tends to be, apart from substantive laws, which are the laws that create the rights and rules of engagement, they always are procedural rules. So the substantive rules will determine what is, the procedural rules will determine how. So if you wanted to go to court in an action involving, say, your house, or running down, or dispute over shares in a company, apart from the company law, apart from the land law, there are rules of procedure that determine how you lay, construct, and access the legal process in an action for declaration of title, or in an action for, say, the variation of a share register in a company dispute. So there are always the how rules, the rules of procedure. So you have a constitution that gives us the framework, affirms universal adult suffrage, makes the rules. Then we have the Electoral Commission Act, etc., etc. Then we realized by 2008 that from time to time, across the board, from parliamentary elections, even from primaries all the way, pre-election registration, you tend to have disputes. And then if you look back in retrospect and you do the analysis, you realize that, oh, litigants, lawyers, election administrators, stakeholders, the politicians themselves, the political parties, are always trying to figure out the right procedures by which to access the court in various election-related disputes. Now, the reason is because our civil procedure rules, as we have them, did not include rules on election. Dispute resolution and how you approach the court. You can put it, first of all, we had civil procedure rules that go to 1957 rules. We revised the rules in 2004 or 2002 thereabouts. But in doing so, remember that we hold elections once every 4 years. So in formulating those rules, if you go through the rules, you see rules on how to roll out various types or courses of action. But there's no section in those rules on how to start an election-related course of action.
Okay.
Anywhere.
Okay.
Therefore, by 2008, I think it was a peace and development conference or so, Her Ladyship Georgina Wood, then Chief Justice, announced a commitment to try and get the judicial service to put together, based on our experience so far.
In fact, this is what she said, and in what she said, I guess raises a very fundamental issue why this all became necessary. She says, quote, "To aid judges in their work, we will publish an easy-to-read, clear and concise booklet or handbook on election dispute adjudication." That's a direct quote. I mean, the judges themselves were at a loss that they needed
Not exactly. We have a principle in law that the law is always in the bosom of the judge, so the judge is presumed to know the law. But it is also inherent to due process that the rules of engagement, the rules of procedure, the rules of doing things are predetermined and they are clear and everyone knows them. So by the time C.J. Wood was speaking, it had become evident that a lot of the disputes that were occasioned at various stages in the process, pre-election, pre-registration, registration, candidature, elections themselves, post-election declarations. If you watched a lot of the disputes that arose and the way that they went into court, the way they were handled, the setbacks that litigants suffered, lawyers suffered, the mistakes that people made, the way that even election administrators and stakeholders would have to look around in order to be able to piece together the rules that affect different aspects of the election. There was the need, as she identified, to put together a one-stop, easy to read, user-friendly manual in relation to election dispute adjudication. And this will obviously be very useful for judges because judges are the adjudicators. It will be useful to lawyers because lawyers are those who represent their clients. It will be useful to the clients themselves and stakeholders and politicians and people like you,
and definitely the media,
who are interested in all of the processes beginning to end, because elections are, because the high stakes game, are always newsworthy and all the related issues. And the greater clarity we have in terms of the availability of a working handbook, the better. It was in that context that in 2008, C.J. Wood started this initiative. And then with the help of development partners and all of that, and consultants, the first manual was published. The manual in consideration now is the fourth of edition. And to produce the fourth, His Lordship C.J. Kwesi Niniabua elevated the process in order to give this, if you want, more serious and deserving consideration in the review. He, I like to say, domesticated the process. Because the process began with retaining consultants to help do this work and also using development aid to do these publications. What C.J. Niniabua did was to constitute an in-house committee specifically tasked with the assignment of revising the third edition into the fourth.
And this is an impressive list of committees.
Absolutely. This committee of eminent juries is chaired by His Lordship Justice Victor Jones Doche, His Lordship Justice Paul Bafo-Bonny, His Lordship Justice Nasiru Sule Badegbe, His Lordship Justice Samuel Mafusiao, His Lordship Clemens Jackson Honyenuga, His Lordship Thanko Amadu, and His Lordship Sir Dennis J of the Court of Appeal, and Mrs. Gifty Prekunyakon, who is Deputy Director, Judicial Reforms and Projects, and of course myself as a committee tasked to undertake this reform, this revision of the third edition into the fourth.
Yeah, and one of the things I found reading, it's a pretty bulky document, by the way, but trust me, you want to grab a copy. And one of the things I found...
By the way, this is the third.
Oh, this is the third. Oh, goodness me, you should...
The Chief Justice will launch
the fourth one is going to be launched on the 24th, from what I understand.
This is the draft of the
But I guess the point I was going to drive at is thanks to His Lordship, the Chief Justice, I got an advanced copy, which I've been reading. And just to the point that you're making about revising it and updating it, the law has changed, I noticed, in the law since even 2016.
Absolutely.
There's a lot that has changed. And I also found that it appears that your committee and the CJ learned lessons from the 2012 I've seen that through various laws had sort of updated. For example, the joinder question precludes people now from joining at the presidential level now, which we saw in the 2012 one. It's such a body of work that reflects the very latest in terms of the laws that govern our elections in Ghana.
Absolutely, and that's so what we do in this volume is revise. You'll find in it every constitutional provision on elections. You'll find in the fourth edition every substantive statute on elections. You'll find in the fourth edition every subsidiary legislation on elections. And then you will find in this edition every significant constitutional dispute that went to the Superior Court.
And the decision.
Okay. And so if you want, is your one-stop shop on all matters relating to elections and election disputes and the procedures in which to addressing them.
Yeah. And again, just to stress the point, and I want to draw in from a quote that His Lordship, the Chief Justice, puts in his forward, just to stress how important this is. At the time when we are going into elections and this fear of violence is upon us, and we start to be doing our own peace campaign here, the Chief Justice stresses the importance of this when he says, by their nature, election disputes must be dealt with expeditiously and in a manner that enables the parties who access the courts in such disputes to be fully satisfied with the process and their outcomes. He says this is the only way to prevent violence, which sometimes arise after elections. And I think this is just one of the things that most people are worried about this year, and the Chief Justice is stressing this is why this is essential.
Exactly, and Evans, this is the way that I like to put it. Elections, as he rightly said, are a high-stakes game. The stakes are high, the emotions are high, the contests tend to be very heated, sometimes unnecessarily. But that's the reality. There's no better way to serve the people than to make available to the stakeholders, those who get busy and preoccupied and agitated by these matters, a volume like this, which has all the rules of engagement set out. It has all the statutes assembled. it has, if you want, precedents. It gives you examples of what happened in court in a matter of so and so before. It brings about transparency. It demystifies the process. So Evans, you can read a book. I can read it as a judge. Lawyers will read it. Election administrators can refer to it and read it. Litigants, political parties, their think tanks and advisors can all read it. So we simplify and demystify the process and make it transparent. Because you see, if all the spectators in a football game are familiar with the rules by which the game is played, and a foul or a free kick or penalty is awarded, nobody descends into the field blaming the referee. Because we all know when a foul is a foul is a foul. And the rules as to what is a foul is made available in advance for those who are minded and sufficiently interested to educate themselves on. So I think it enables judicial accountability, it enables transparency, and it's a service to the population in a hugely significant regard in relation to a matter that is that important. And there's no better timing than now, when we are all poised and going. And Evans, if you have regard to the public interest, and you covered most of these elections and the disputes that ensued, if you look at this, the scale of public interest, it justifies the priority His Lordship the Chief Justice gave to this work by designating a committee of that pedigree to do the revision and make sure that we avail to the stakeholders, the Ghanaian people, the political parties, the EC, lawyers, judges, all manner of people interested in Ghanaian elections. That this is a working handbook, one-stop shop. You will find practically most of the things that you need. So that we are all, so to speak, on one page in the matters that would arise, that are likely to arise.
Yeah, I mean, and you made an important point. One of the things that struck me is when the Chief Justice says in the forward again that he's grateful to the committee, yours, putting together at this time, so that the necessary stakeholder consultations will be done before the elections are held on December 7th. And I'm curious that the Supreme Court judges will be doing consultations. I mean, and that is the level of transparency that I guess...
Those consultations will not necessarily involve the judges. Understandably, judges want to stay out of the fray. But to the extent that they are the custodians of the law and final adjudication of disputes, we can go this far in assisting and enabling the process. Because after all, if the politicians, their think tanks and advisors familiarize with this manual, they know the rules. Beyond mischief, they will advise themselves. Now, this will take some power out of the hands of those who ordinarily are the sole repositories of technical knowledge. And so they advise their clients.
As in lawyers.
As in lawyers, where to head. Informed clients will be able to ask back the lawyers some questions. Because they have looked at the manual on election dispute adjudication, and they can ask informed questions and query some of the decisions and advise themselves.
Yeah, and eases the tension a great deal, because
absolutely
knowledge is
is relieving. And so what His Lordship has sought to do is to make sure that this knowledge doesn't stay in the monopoly of just any group of people. Number two, make sure that the knowledge which is scattered in different statutes, and you have to look in multiple places. And trust me, in preparing a brief, it's very easy to miss a legislation. There's legislation which is repealed and you didn't address your mind to it, and you walk in with a law or a provision which has been repealed. This saves lawyers and saves judges and saves everyone that kind of headache. And Evans, to the credit of His Lordship, the Chief Justice and the Judicial Service, against the constraints with resources, all previous publications of this manual were donor-sponsored. The Chief Justice ensured that even without donor support, this manual has been produced with, out of the just squeezing the lean resources at his disposal.
Oh, I see.
Yes.
I'm going to talk a bit more about that when I return. Stay with me. My guest on PM Express tonight is His Lordship, Justice Yoni Kulendi, Supreme Court Judge. When we return, we'll talk about the funding question that he's just raised. And of course, we'll look into how this, in essence, this fourth edition, how you access it, if at all will be available. Stay with me. You are still live on PM Express. My guest in the studio is His Lordship, Justice Yoni Kulendi, is a Supreme Court judge, as we talk about the impending elections and election adjudication in Ghana. Just before we continue, there's some breaking news story I want to bring to your attention. It relates to the Martin Amidu resignation and the presidency. In fact, the office of the president has just issued a very detailed response to him. He resigned yesterday. I want to just share with you just bits of the essential part of this, as this just been developing over the last few minutes. It's entitled Resignation of Appointment as Special Prosecutor. It says, I write to refer to your letter. This is the 16th of when he resigned, and quotes the relevant laws. It says, the President has taken note of your resignation per the President's Chief of Staff's letter to you of even date. We know, however, that even before the President had been given the opportunity to react to the contents of your 4-page letter, it had been put into the public domain prior to receipt by the President. I am directed by the President to respond to correct the errors of fact contained in your letter in order to provide a complete public record of the issues. I just want to quickly highlight a few of the key issues, and then we'll wrap up in the studio. At the onset, it must be made clear that throughout your tenure as Special Prosecutor, neither the President nor any member of his government has interfered or sought to interfere with your work. Indeed, it is noteworthy that in your letter to the President dated 16th, you stated in part in relation to the novel nature of the report on the analysis of the risk of corruption and anti-corruption assessment of the gold royalties monetization, and the President quotes, this has been made possible by the courage and commitment of His Excellency the President of Ghana. So the President denying that he interfered in his work. Again, in recent 3rd August 2020 letter from you to the Chief of Staff at his office of the President, you stated in part as follows: I have remained in this office this long out of personal respect for the President's shared commitment with me to fight corruption. Again, third, it says on page 1 of the letter, you claim that you had been convinced beyond reasonable doubt that His Excellency the President had a mistaken belief that you would hold office as his poodle. Now, in substantiation of this allegation, you allude to a request by the President Chief of Staff, pursuant to a directive by the President for you to meet the President in the morning of 21st October to discuss a report you had delivered to the President, which you had described as analysis of risk, corruption, and anti-corruption assessment of the transaction documents of the JAPA. Indeed, you also described the report as being in the nature of a compliance audit or an Inspector General's report. It is instructive that the 13-page document you delivered to the President was in fact not the actual report, but the summary, which also included information about other investigations. I will conclude so you could find it on my journal online. Finally, you also accuse the president of being a judge in his own cause. This is the unkindest cut of all. I'm quoting here. Finally, you also accuse the president of being the judge in his own cause. This is the unkindest cut of all. You did not and have not alleged that the president is or could be the subject of adverse findings or investigations arising from your assessment report of JAPA transactions. It beggars belief, therefore, that you would insinuate that the president has himself something to hide and seeks to be a judge in his own cause. As a lawyer of many years standing, there's no doubt that you know that if one is not party to or has an interest in a matter, one simply cannot be described as a judge in his own cause. That statement is most regrettable. We hope that the above statement facts settles the matter. This is from the presidency in reaction to Martin Amidu. I want to return to my studio and conclude with the issues relating to the election adjudication. Justice Kolenda, we were talking before for the break about the funding for the manual. You talked about the donor funding has dried up, but the Chief Justice still found money from the Judicial Service, is it?
Yes.
Or state coffers,
yes,
was it?
No, from Judicial Service sources to fund the publication of the manual.
Okay.
Otherwise, crucial as it is, from all that we have said, we will not be here speaking about the manual ready to be launched. It's a commitment of the Chief Justice to make sure that this all important material is available in its latest form, okay, updated, and as you would observe, in the last few years and in the build-up to this election, we've had some revisions in election-related subsidiary legislation. CIs have been repealed, new CIs have been introduced. There's been some flare of constitutional litigation in the courts, even in relation to the pre-registration processes, etc., etc.
This is a full update of all those.
Total, complete overhaul, full update up to the latest, the most recent constitutional matter, election dispute related that was determined is in this volume.
Is this free? How do we get it?
That's the interesting part. In spite of all that I have said and the limitation of resources and all, the tradition has always been that because it is so important, just for the same reason maybe that Bibles are not sold, the Judicial Service have always provided this all-important manual free to stakeholder agencies and institutions, the faculties, the Electoral Commission, and to judges. I have said somewhere that, and this is not the service's view or the CJ's view, but I would have thought that given how important this manual is, how handy it is, how much it simplifies and assembles research that lawyers and judges and stakeholders would take months or weeks to find. I think that it will be fair to put a price to it, at least for private practitioners.
But it's free now.
For now, it's free. I hope that a decision is taken by His Lordship, the Chief Justice, to make sure that those who will use it for profit pay for it.
Yeah, okay.
So at least, Evans, now I'm on the side of the judiciary and party to the scarcity in-house. So we can at least recover some money back.
I'm grateful, Justice Kolendi, and the launch is on the 24th. Thank you for joining us, the Chief Justice. Enjoy your rest of the evening.